You know something's up when a person's been trying to get back into court for 18 to 20 months, okay, and finally got her back into the court.
Yeah.
And it was on stuff that that could have been done by any of the lawyers. But I honestly do believe it's to do with so many years of lawyers doing an affidavit one particular way. Okay, and what whānau needs to be aware of is when you've got a lawyer, they will always say to you, here's the paragraphs, this is what they're saying in their affidavit, you give me your answer to that. My answer to that? No, you don't give them your answer to it. What you do, you get your OIA files, and anything that is in their affidavit, you go through your OT file. If you're with the hospital, you get your OIA from the hospital. Okay, and everything that they are saying about you in their affidavit, you get the professional's evidence of the file that says opposite to it, and you submit those as exhibits. And instead of you saying the big long-winded paragraph as to what your story is, okay, like for instance in our one, okay, we had a doctor email the 20th of July, okay. So rather than turn around and explain what's in the email, okay, Dr. So-and-so email communication, refer exhibit such and such. Highlight the section you want the person to read. Hello. How can they argue with it? And it's the good point about it is the last time when she had to go to the court, okay, she got asked a question. Is it not true that this statement was made on the page that you were reading? And she answered perfectly. Well, it may have been, but I don't know because I didn't write it.
Exactly.
So you'd have to ask the person who wrote that.
And I think the reason for this is twofold. It is one, not only that silence is acquiescence, but you have the right to remain silent. They're going to use what you say against you, never fucking for you. So why would you help them verify anything they've written? What you need to do is and secondly, the court doesn't listen to the parents or the children. The courts only listen to the professionals. So use the professionals' information to your advantage. Don't you go around making statements you can't prove or back that's not going to get listened to anyway. Use the evidence they've already got in the OT file and in the hospital files, and use the professionals' evidence and just submit that as your own using their fucking comments. Simple.
The one thing I've got to say though, okay, is this: everybody is aware of the fact that if you go to an FTC, you cannot record the contents of an FTC. If you're speaking with doctors and that, you cannot use that information. Okay, the most important part for you to be able to submit that, you must have applied under the Official Information Act to get the information. Once you've got that, I say this to people, okay, if you've got your own files, okay. So, a lot of people get mad reading their files. Okay, so what I say to them is this, okay, and it's understandable that they do, but I say to them this, okay, take the file, open it up, read it like you're reading about another family. Okay, when you're reading through, if you see parts that pisses me off type thing that's making me so angry, highlight it, save that page. That's an exhibit. Okay, anything that makes you mad in that respect, highlight it. Okay, if you've got it in an OT file where a social worker sees something here, okay, and then later on down the track they completely contradict it, you take those two pieces of paper, put them together, that's another exhibit. When you question them on these things, okay, you can then turn around and say, okay, is it not true you made this statement on such and such date according to that documentation? Yes, it is. Is it not true that 3 months later you made this statement? Yes, that is true. Right, I remind you, you are under oath. Which statement did you perjure yourself with?
Yeah, because the two statements contradict each other.
That's right. Now, what they also don't realise is this, okay, by doing that, you've also brought Section 444 into play, okay, because Section 444... the Section 444 says that they are not liable for anything that they put in any reports or anything like that. Then it states, unless those reports or anything that they file is used in bad faith or is written in bad faith. So if you've got one comment and one file, and then you've got another one and it contradicts itself, the two contradict one another, naturally that has been used in bad faith. Okay, so therefore you got them under Section 444, so you can get them as a public servant in regards to the liability.
Section 444 is liability of persons providing reports.
That's right. And what does a social worker give? A 132 report, a 186 update report every 8 weeks. Yeah. Okay, any report that they put in. But it is also considered that if they put something on file, they are doing case notes, which are reports. Okay, so it's a report about your case. So if one says one thing and then another thing contradicts that, we've now got liability. Okay, yeah. So as a public servant, they become liable for it. Okay, under the Public Service Act. Okay, well, what also is handy, okay, is the fact that if you can find out that person's details, yeah, you've got the evidence to also turn around and do a private prosecution for fraud, fabricating documents.
Perjury. Well, for perjury as well. Section 109.
Yeah, you've got a few different options there, but people believe that they're not able to be held accountable, but that's wrong. Look at your files and you can find so much evidence where they're perjuring themselves, where they're fabricating documentation.
And the key words are evidence of bad faith.
Yeah, that's right. And the other thing you've got to realize, okay, people look at an OT file when they get it, and they go, oh, so much is redacted out, okay? Here's how you complete an OT file, okay? When you get your OT file, a lot of the pages will have full blacking out, okay? Read what it says about the Privacy Act, and it's in regards to the Ministry of Justice, okay? Here's what they don't do. They don't redact out the date of that form. So what you do is you go to your court minutes that you've got from the judge, because all ears get it, okay, and you find the date for that particular one. Make a copy of that, pull out the black page, and put in the minute. That's how you start completing your file. When there's doctors' communications, hello, the doctors don't turn around and redact the files, so you get the full clinic notes and everything. And the other important thing to note, if you're dealing with doctors, okay, the doctors will supply a medical summary of what they want OT to have that they can put into the court that helps them. Now, where people go wrong is they accept that medical summary. Okay, you are the parent, so as a guardian, especially the mother who has natural enduring power of attorney. Okay, the mother can actually get more information than the father. Okay, so if mum goes and applies under the Official Information Act for all of the information on her child, okay, what then happens is you've got the full medical file. So where they've got the doctor stuff and it's been redacted out, you just pull that page out and you make a copy and put it in from the medical file. All of a sudden, you've got maybe 1,400, 1,500 pages, but now the file has started to look how it should look because each place doesn't redact their own information.
Yeah.
And the same with the police files,
Another thing I'd point out to people too is when you're going into court, it's a two-dimensional system. It only exists on paper. It's rules, words written on paper that men and women follow, believing they've got authority. It is not an emotional place. It's not Dr. Phil, all right? The courts don't give a shit about emotion. If you go in there emotional, then you'll be treated like a nut job to begin with because you'll be full of emotion and wanting the judge to listen to you. He doesn't care. He cares what's written on paper. So do not go in there full of emotion. Turn that anger into just pure coldness. Be as cold as they are back to you because they don't give you any emotion. You can jump and scream and say, why don't you care? They're not going to listen because they don't have emotion. It is a two-dimensional system. You don't get it. That's why it's called stationary. It exists on paper. Unless a man or a woman acts on that, it doesn't move. There's no motion. It's stationary. So you've got to remember these things, people. Don't go in there with emotion because you'll just be classed as a nut job and ignored, likely to be held in contempt.
Or become like a judge and throw your paperwork around and throw your toys.
Exactly. Throw the toys out of the cot and have a right little fucking tantrum until someone sticks a pacifier in your mouth. Hey, Tim.
Exactly.
But yeah.
Yeah, exactly.
Got to get that in when I can.
Yes. It's not that hard to get kicked out of the court. I can honestly say that over the last 12 months, I have had to change my demeanour in the way I deal with people, because my demeanour 12 months ago was very much like everyone else's. Okay, the easiest way to deal with this is go just grab the child, but that wouldn't get me anywhere because of the fact you'd have kidnapping charges.
No,
So the unfortunate
you're just
part.
causing more troubles for yourself, really. Don't let your emotions rule what you do.
Yeah, and so the easiest way to be able to deal with it that they don't like is to, take the legislations and the acts, and use them against themselves. And then, like I said, as we just found out, attack the uplift warrant. Because if you had your child uplifted and you're trying to review or discharge, if you're going to review anything, review the uplift warrant. The uplift warrant does not have a court order attached to it. And that is why they have to go back to the court within 5 days. If it's the Section 78,
not just a statement, with an affidavit.
Yeah,
they must go back.
It's got to have an affidavit with it. And if it doesn't have an affidavit, like the most important document for any uplift, if you know an uplift's happened and it just come, notice of intention to appear. That's the very first thing you want to file. If we had to go through this as a whānau again, the first thing I would file would be the notice of intention to appear. But then what I would turn around and do, because that's slowed the process down, is I would then go straight to the High Court and pull it straight into the High Court for a judicial review.
Judicial review of the uplift warrant.
Because they've already turned around. See, the problem is
nothing under statutory power has been enacted or put into it at that point.
Yeah, that's right. And so, and the other thing you got to realize,
but I'm still listening. Okay, I'm just ducking out the door for a sec, but I'm still listening. Go for it.
Yeah. So the best thing you can do is notice of intention to appear on any uplift order. That will buy you a little bit of time. The other thing I would do is do a judicial review to be able to have that order overturned. You can also, within that with a judicial review, the judicial review, you can say what you are hoping for the outcome to be. So on a judicial review like the one that we have done, we have put Family Court Rules 2002, Rule 34C, which what it means is any order that's just been, I'll rephrase this. Judges make decisions, and so a court order is a decision made by a judge. A warrant is a decision made by a judge.
Is it a decision or direction? They do make both, don't they?
No, it's actually worded in the judicial review process as being a decision made. Because here's the difference between a direction and a decision. A direction is when they are telling you that, for instance, like how they say, I'm going to direct that there will be a continuation of a Section 78. Whereas the decision is a 78 interim order moves from a direction to a 78 to become a decision.
So decision has power, whereas a direction is just like go past, go straight to jail.
So there's different meanings behind them, and it's only on a decision, that orders can actually be made. So when I say orders can be made, like you've got direction conferences and you've got judicial conferences. Now you've also got what they call Pickwick hearings. And so on a Pickwick hearing, P-I-C-K-W-I-T-K. Pickwick hearing. I learned about that one because I can't remember what I typed in, but I think it was something to do with hearings in family court. And a Pickwick hearing is where a judge can turn around and take a judicial conference or a direction conference, and go, right, I'm turning this into a Pickwick hearing, which is a quick hearing because I want to make a decision. So what ends up happening is, you know how they muck you around for months on end, right? So if a judge decides, I could deal with this just right now, you know how you always get a judge says, and I make of my own motion this direction. So he or she can do that by changing the directions conference or a judicial conference to a Pickwick hearing, and it makes what it does is it changes the 15 minutes, whatever time is left of it, or that 15 minutes, will have it on the take. It changes the rest of it over to a mini hearing. Now the decisions can be made. Okay, so where they say I can't make any decisions today, okay, because I forgot about it when I went to court. He said, "Well, I can't make any decisions today." And my first thought was before I went to court, right? If he's going to say that, I want a Pickwick hearing because he can change it straight away. Okay,
Yeah.
and I forgot all about it. My head was thinking of other things, but so Pickwick hearings are based on judicial conferences and direction conferences, and also teleconferences. So you can turn around and say to a judge, "Well, Your Honour, I'm aware that you could make this a Pickwick hearing today and make that direction and make that decision."
Yeah.
And they don't like it. Like I remember when we went into the court, and I turned around, like I said, we went into the court, and I straight out said to all of them sitting there, all of you people in this courtroom, and I include the judge, okay, you all say we have no idea what we're doing. Okay, so if we don't know what we're doing, why do you need an extra lawyer, and why is there a QC involved now?
Yeah.
Obviously, we must know something. And I said, look, I understand the act a lot better than what you think. Okay, I've already told the site manager that as well. Because I told the site manager of Lower Hutt, look, you use 49 sections out of your whole act. He goes, yeah, so I'll fight you back with the over 400 that I can fight you back with. How's that?
Poor old Dino.
And he said, well, you do what you need to do.
Dino did not like that at all.
Oh, no.
Yeah.
No, he didn't. No. And what got me was when he turned around and was it a few months ago now, when all of a sudden he knew the Oranga Tamariki new board that was coming and we're getting involved. All of a sudden, he decided that it was okay for him to answer on behalf of Kelvin Davis and Suwada in an email.
Oh, really? But he doesn't speak for them.
So it's like,
no doubt,
the
authority to
I
speak
haven't from you in 10 months. Yeah, and that's what I said to him. Look, I don't believe that they asked you to reply, okay, because number one, they have their own PAs, okay, so why would they turn around and get you to reply? I said, Kelvin Davis says Simon Harding, he's quite capable of replying. And I mean, if what he was saying was true, then why was it? When was it? About 4 weeks after, my daughter asked for an appointment with Kelvin Davis, and she got a reply. So if that's the case, why didn't he get Dean to reply?
Exactly, and as far as like if your opposing counsel's table is getting more and more fuller with more and more reinforcements, you're not doing something wrong. Put it that way. You're doing something right.
Yeah.
If the court wants to appoint
and
you,
so
if the court wants to appoint what's called an amicus curiae or a friend to the court, the amicus curiae is there to help judge. The amicus curiae is not there to help you. And anything you say to that amicus curiae, he'll go ahead and repeat straight back to the judge. So remember that.
Yep, and it's funny you say that because the judge turned around and not only appointed a counsel to assist my daughter, but also appointed the court one.
Yeah, to assist the court.
No. There was one for my daughter. Okay, so she just got the part done that she needed to get done. Okay, but the last time we went into the court, there was a counsel to assist sitting next to him.
Wow, which means you get.
But when you can. Yeah, when you can get a judge that turns around and says, and today the what do they call it? The registrar person that helps them in the court. Okay, the case manager. The case manager. No, case manager. Yeah. So the case manager has informed me there has been 27 applications made in the last 24 days. It's like, yeah, there is. And if you keep going this way, there'll be more too.
Yeah, there'll be 60.
But they didn't like the Normally a judge is sitting there with his paperwork like this on his bench. Okay, we had him up and down the bench and on the floor getting paper.
And if you if you hear a strange noise, sort of a that judge might not have pants on underneath that table. You remember that judge over in America? Who was sitting there with the suction cup on his knob, and people could actually hear the suction cup from getting.
Oh my God!
He got kicked off the bench for that.
It started as an average day in the courtroom of Oklahoma District Judge Donald Thompson when court reporter Lisa Foster suddenly noticed the dapper and distinguished judge making an unusual noise.
It would be silent in the courtroom, and he would start in on this pumping sound.
Now, you're sitting there in court, and this is what you hear. Listen. And then you hear it again.
Turns out that noise came courtesy of Judge Donald Thompson's penis pump.
While he sat on the bench, he apparently felt it necessary to use his penis pump.
You know, he wasn't just doing these things in traffic court. There's a couple of murder trials he was on.
If someone's life is in the balance, you're looking at life in prison, and this guy is playing around with a penis pump?
Judge Thompson used his device during 3 separate trials between 2000 and 2003.
And when I stepped into the courtroom, the judge had that pump in his lap, and I saw his penis.
You know, I mean, he was so blatant about it that he would leave the bench and leave the thing there.
As he started doing it more, it was almost like he got careless.
You know, that's how they got him. A cop came around because they were wondering what it was, and they saw it, and they photographed it during a recess.
People know too much now about what goes on behind those robes.
There's a lot of things I believe that if whānau knew about it, they would probably have their kids back already.
Oh, of course.
But those are the most important things that I consider to be really important parts of the Act. The other thing that I will say, okay, Section 110, which is guardianship, okay? When the judges turn around and they give additional guardianship to Oranga Tamariki, okay, this is something that parents are not aware of. Additional guardianship can only be given for one 6-month period, okay? Then, after that period's finished, they can give them one more lot of 6-month guardianship, additional guardianship. Okay. Now, people think that because OT got additional guardianship, that OT are the only ones who have say in it. Wrong. Okay. It's a case of they're an additional guardian. Okay. And what they do, okay, we were pulling the court up on this because 6 months had gone by, and then a 12-month order got put in place. But that's illegal too, because the Act says under 110AA that an additional guardian can only be given 2 lots of 6 months. Yeah. After that, it's either no additional guardianship or you bring them in as a permanent additional guardianship, but that's done under 110. And so you've got to have 110.
And I'd point out those people that can be assigned the chief executive and iwi or social service, much like the other section, the cultural social service. Exactly. Same as 126. So it's
same as 126. Yeah. Now the other thing that people might not know, okay, is this. Okay, under Section 7AA, which is the Act that they brought in regards to iwi and everything like that. Okay, if you go after that, if you go to the next one, sections 7A through to 7F, okay, they state about delegation of work. Okay. Now, I'm pretty sure, I can't remember whether it's E or F. It's one of those sections has the Public Service Sector Act in it. Okay, and so what it says under that, okay, is one of those sections is that the work to a social worker, 7E, work to a social worker can only be delegated providing it has the minister sign off on it.
Yeah,
it has to have
this sub-delegation of functions and powers by delegates who are not social workers. The section applies if a delegation referred to in section 7B or C is made to a person for the sole purpose of sub-delegation to whom the chief executive otherwise gives approval. And must have the chief executive.
But so you'll see it's got subsection section 2 of the Public Service Act. I think it's 2016.
Yeah, a sub-delegation by the delegate of a function or power under clause 2, subsection 3 of Schedule 6 of the Public Services Act 2020 is subject to subsection 3.
Yeah, and so what it says under there, because I've got it up on the other screen over here, is delegation of function or powers. Okay, section 2, subsection 2, it says, however, A, the delegations of functions or powers delegated to the chief executive by a minister requires prior approval of that minister.
Yeah.
And you see, what we've been pulling them up on is this. Okay, what it means is how you get assigned a social worker. We always turn around if they change the social worker. So under section 2 of your act, section 7E, I'm pretty sure it is. So I always say it's either somewhere in section 7A to 7F, okay? The Public Service Act section 2 comes into effect, and that requires ministerial sign-off for you to delegate that work. It is also a good thing to know that when a social worker goes, well, I've got the social worker helping me, so they're going to, they'll be working on your case. Well, that's sub-delegation, and they can't do it without ministerial sign-off.
Yeah.
But the first thing they'll turn around and say to you is, no, you're interpreting the Act wrong. Well, how do you interpret it wrong when it's in plain English?
Yeah, exactly.
I mean, I know some of the acts, they make it gobbledygook so you can't actually understand it, but it quite clearly states the delegation of functional powers delegated to the chief executive by a minister requires prior approval of that minister. So they can't delegate the work out to the social worker until they've got the Minister of Children to sign off on it.
And I highly recommend to people that are reading legislative acts, always go to section 2, the interpretations, because a lot of the time they will change the definition of a word to mean something completely different from what you think that word means, because we're talking legalese versus English here, legal jargon. I mean, that's what a lawyer's for. They're there to interpret legalese into English for the layperson.
And it's a pity that half the time those lawyers can't even do that.
Yeah, well, of course, they're as good as their $2 pair of
It's always going to, the legal people are always going to use the avenue that is going to earn them the most money.
Yeah.
And if that means keeping you on their books for years,
and not the quickest
so
solution.
that means if it keeps you on their books for years, then they keep getting paid. Simple as that.
Yeah.
Okay, and the longer they keep you on there, and the longer your children are under there, okay, because you've got to remember that that when they apply for the legal aid for you, if you've got 3 different children, that's 3 different lots of legal aid. It's not one.
Yeah, they're just rubbing their hands.
So when you look at it from the point of view, that some people have 7, 8 children they get taken off them. Okay, at an average of $12,000 legal aid a year. Okay, just off your one whānau, children being in care, there's $96,000 that they've been paid.
Easy.
Why are they trying to make money off of kids and their kids suffering? And half the time the problem is the kids aren't suffering. It's just a case of, we got social workers that just want to be able to put them in care so that they're reaching their quotas. I mean, we've just been told that in Lower Hutt alone.
It's all a numbers game.
In Lower Hutt alone, apparently there was, from memory, I think the person said 17 social workers have left the Lower Hutt office in the last 2 or 3 months.
And why would that be?
Because that's the most, well, from what I know of, it's the most corrupt office in New Zealand. So
exactly right. Because they haven't got their shit together. And then they turn around and blame the Social Workers Registration Board for the training of the social workers.
Yep.
So
and in some cases,
responsibility, not us, go look at them.
Yeah. And in some cases, okay, my opinion of the new Oranga Tamariki board, okay, is be very careful out there, whānau, because, okay, you will bring to attention what is going wrong in your case. And if, like a couple that I've heard of, they will use the information that you're giving them to clean up the mess and get rid of the social worker.
Yep.
And so if that's the case, how is that helping our children? How is that helping the tamariki out there?
It's not.
Okay, we're getting rid of the problem of the social worker, but that just brings in a new social worker, and the kids and our tamariki are not coming home. And that's what this latest uplift that happened down in Christchurch, what I'm looking at is the fact of, okay, what happened to the fact that there was the triangle of the board being involved in social worker puts it onto the board then put it to the court if they think that yes, it should be done. So what makes a protected parent wrong? Because from what I've heard, that case is of a mother trying to stop the child going to an abusive caregiver that was known about. And if that's the case, why are they trying to get an uplift order? The reason I believe, is because of the fact that I would hazard a guess to say no sign-off from a judge. Okay, issuing officer would have signed it, and the issuing officer is only someone from administration higher up in OT.
Yeah.
And when you consider that those place of safety warrants that they use are on their own Oranga Tamariki forms and are not, they don't have to go to a judge to get it. They have to turn around and copy and paste it into Word, print it, send it off through the EGD. Okay, but I mean, I've heard of cases, and I know of one case for sure, where the social worker had turned around and put the children's name on the place of safety warrant, absolutely no signatures, no dates, no nothing, and tried to uplift the children. You know, false warrant,
So
completely
wrong.
false warrant. You know, and like the reason I can say I can confirm that, the person sent me a photo of the actual documentation, okay, with the page turned over, and there is no signatures on it. The two children's names are on it, but there's nothing else.
It's almost like an English version of the licensing fee, where it's just a bulk handling center. It's not a court. It's just a bulk handling center, printing off the
Pretty
forms
much.
and going and collecting or going and using warrants for entry to search people for their tallies.
Going by what they're doing,
They're
going
not
by what they're doing, there is absolutely no reason. Like the place of safety warrant that they use, okay, you can bring it up on your own computer. You can copy and paste it into Word, print the documents out, okay, and theoretically you could make out you're the issuing officer and go pick the children up.
Yeah, but to be an
available.
official document from a court, a court's official document must have a court seal on it. Do you see court seals on any of those documents? No.
No.
Not stamped by a court, not signed by a judicial officer. It's not valid.
And here's the other thing. You know, when a social worker knocks on your door, tries to give you a warrant that's got nothing, no signatures on it with your children's names on it, okay, and you slam the door shut and they chuck it through the window and huff and puff away, you know that wasn't valid. Because I told this person, if it's a valid warrant, they'll come back with police. Okay.
Yeah. And if they're doing something correctly, they won't show up at 9:30 at night to do it. When you can't contact a lawyer, you have no support whatsoever. That's why they come at night time. You're screwed. You're asleep, you're half dazed. They're going to come and take your kid and cause as much distress as they can in the process.
And I can honestly say you're completely correct there, because the warrant for our granddaughter was executed at 12:18 in the morning.
There you go. And it's, I mean, yours is only one of the many uplifts I've seen happen late at night.
Mm-hmm. And the thing is, when you know, okay, when they come at that sort of time, it's like, you know, are they actually thinking of the care of the best interest of the child? No, they're not. Okay, because
and an example would be they'd let the child stay for fuck asleep until they're awake during the daytime.
Yeah, exactly. Yeah, exactly. And that's the thing with these warrants. Okay, look, they actually state, I think it's the second lot of paragraph down, that okay, people give their children over because the police and OT say we have an uplift warrant. No, you don't. You have a place of safety warrant which clearly states that yes, you can enter a premise, but that, okay, you have to be, and it's in writing on it, that you have to be without reasonable doubt, you have to believe that that child, as you see them right there and then, is in need of care and protection. So when they come into a house and they see a child that is sleeping with their eyes closed, please tell me how
they're not in need of anything other than to be left the fuck alone.
That's right. But what do the police and OT come to the door with? We have an uplift order. No, you don't. You've got a place of safety warrant that tells you that if you believe at the time you see the child that they're in need of care and protection, then you have the grounds to turn around and restrain them and take them with you.
And
that's what it says.
And the child isn't in need of care and protection at that time that you show up, walk the fuck away again.
Exactly, but they don't do that. They use it to just turn around and say that. But you see, the worrying part that I worry about is this, okay? If the average everyday person like me can find the place of safety warrant online, okay, just like how they turn around and say, yeah, people impersonating police, what stops someone turning around and impersonating a social worker and using that warrant?
Exactly right. Exactly right. It's giving all these little pedos,
you know, there is every possibility happening. How many times do we hear? Well, I mean, there was a case down here at one stage where this guy went to what's it called, Turner's car auctions, and he bought an ex-police car and it had all the lights and everything in it, right? So he was going around Lower Hutt and he was pulling everybody up, and all he had was one of those police scanners on the side of him, but he was making out he was a detective.
Classic.
Until
I can't really speak, because I do have a Stalker dual DSR speed detection device in my car, but I like to check the speed that the police are doing. I can't issue a ticket, but I can put them on blast on YouTube, which is far more effective than issuing a ticket.
Yeah. Yeah. But this guy, it was quite funny in a way because he'd pulled all of these people up. Then he decided to pull his car up, and he was very horrified when he found out detectives got out of the plainclothes. But yeah, they had left all the lights and all the flashing stuff. And he just hooked it all back up again.
Well, it shouldn't have even been sold that way, though.
Exactly.
They should.
Yeah,
That's public fucking property that they shouldn't be selling on because it would be illegal for anyone other than officers to use.
Exactly.
So
But yeah, I hope it's been quite informative for the whānau out there because they do have rights. It's always held back from them the knowledge. Okay, and I think it's very unfair that they get, if they can't afford representation, they're given court-appointed counsel who just don't give a toss. And, when it comes down to this kind of thing, if you've got the confidence to self-represent, you will get your case over and done with a lot sooner. Why? Because they can't collude with your lawyer anymore. Okay, and when they can't collude, they don't know what's going on your side. But I would also like to say this: when it comes down to doing these sorts of applications, one thing that whānau really need to be aware of, because there's a lot of people out there that have big whānau. Okay, so if you've got brother, sister, mum, dad, auntie, uncle, extended cousins, okay, 126 applies to the whole lot with the wider whānau group. Okay,
they can
the clever way to deal with it is if you want to give the judge more options, because at the moment he's going to have yourself and OT.
Yep.
Okay, and it doesn't matter if you've got 100 whānau members that qualify. Fill out a section 126 application and put 125 under it. Okay, you've just given the judge 100 options to where to put that child.
Exactly.
And so therefore, okay, like 7AA states, okay, if they're not placed with kin, okay, and this was done in the lower hut one, if the judge stated this, okay, under section 7AA, if the child is with a non-kin caregiver, okay, and a kin caregiver comes forward, I have no option but to take that child out from under Oranga Tamariki and give the custody to that kin person, the whānau member.
Which makes perfect.
And yeah, but you see, the thing is, the lawyers won't tell you that. Okay, I've got 3 people I'm helping at the moment, where each of them has got 3 people applying from their side of the whānau. Okay, and as I say to people, the more you can put forward, the more options. Okay, and it's really bad when you get I got one case where the girl, they did an FTC, okay, and there was a contingency plan. Okay, if it didn't work out, the child could go to the father, or the father's mother, or the father's father. Okay, but the minute they said that she breached the 101, okay, the FTC, and they checked the 101, okay, we're not doing the contingency plan. Okay, why? Well, the father's with you. Well, the father was with me when you made that contingency plan, so I don't understand that. Okay, and I said, no, I don't understand it either. Okay, but at the end of the day, okay, if you go through an FTC and they make a contingency plan, they have no chance of actually keeping to it. They will just go, no, we got the custody now, we don't care.
Yeah,
because that's what they do.
Just throw the plan out.
And so that's what people do. Yeah, so they just throw, you'll always get told, okay, you've done an FTC plan, we got the custody, okay, and you're always thinking to yourself, right, we're still going on the FTC plan. Here's the catch-22 that they don't tell you, okay? You're still doing the 128 plan, but because they got custody, the plan's null and void. It doesn't exist anymore.
Oh my God.
Okay.
So as soon as OT's got custody.
Hence why.
Yeah.
Well, if a 128 plan is only set up to be able to turn around and if you're going to work, they're going to work with the whānau, right? Okay. So if they're not having to work with the whānau, if they're having to work with the whānau and then they get an order, they're not required to work with the whānau anymore because they now have custody. So the 128 plans are only valid if you've got custody. Okay. Wow. And if you happen to go into a 128, go into a family conference to do a 128 plan, you've always got to be aware of this. Okay. If you can't come to an agreement, they will say, right, it's over and done with, we're going to court. No, it's not. 136 says you must turn around and reconvene that at a later date because you could not get an agreement.
Exactly.
Okay. So when it comes to that sort of thing, 136, you can also ask for a FTC to be reconvened if you've gone through it in the past. Okay. The Section 136 allows a reconvene, and this is all you've got to do is if you've had other whānau member at that 128 at that FGC to make the 128 plan, you get just two of them, okay, that say this needs to be reconvened, and it must be reconvened.
Nice.
Okay, and so where they haven't turned around and told you that you can do this stuff, okay, all of a sudden you're saying, no, I want a 136, and I've got two people that are applying for it, okay, two people that are saying, no, this is not working out, okay, and it's got to be reconvened, okay. Now here's the catch to it. When they do a reconvene, they tend to turn around and say, right, well, we'll get this person, this person, this person. They weren't there before. A 136 only allows the reconvene of the people who are at the last FTC.
Nice.
So you can't, OT can't say, well, we want to have this person, this person, this person, because they try and bring in, they'll try and bring in psychologists and everyone like that. No, sorry, you have to go by the last list of people that were invited that we agreed to.
Yeah.
But people don't know that, so they let them do what they want.
Yeah, they just stack the pack completely against you, and you're overwhelmed.
Exactly. Yeah, and so what people don't realise, okay, is this is the other thing. When they reconvene an FGC, they then got to turn around and say, does everybody agree there's care and protection concerns? No. That's it. FGC's over and done with, you're off the court.
Yeah. And that
because when you reconvene, they still got to ask that question about the care and protection.
Yeah.
So that's the other way around it.
And if they don't,
I think we've given them a bit of knowledge tonight, so that's good.
Yeah. There's a bit for people. I'm sure they're going to be playing this back a few times to try and catch up on all of it. But a lot of knowledge.
But I'm still planning on doing some little videos where it's going to have sections and stuff like that as well. Anyway. But I just thought, if we get together, I mean, I'll wait till you put yours out, and if it's enough, then I'll just leave it. But I just wanted to, I thought it would be easier, how you were saying, talking to each other than, because you're bouncing ideas.
Exactly. All right, bro. Well, I'm off.
You a good one?
I'm off with Mr. Evans in the morning at 9 o'clock, and given it's 1:15 in the morning, I better get some sleep.
Oh, really? Sorry, okay, I didn't realise that. I didn't even look at the time.
That's
Where are you guys off to?
Oh, we're going to go and see a Labour electorate. So I don't know what Steve's up to, but he just needs some backup to come with him. So I'm available.
Is that Shannon one, isn't it?
Oh, I don't know. He doesn't like getting into things.
I'll see you able to actually get some sleep and go with him then.
Yeah.
But all good. Have a great night.
Have a good one. Thanks very much.
Bye.
See ya.
Bye.